everyone. The first matter to come before the court this morning is State of Ohio versus Gregory Kudla.
Kudla, correct, Your Honor.
Typically, both sides will have 15 minutes to present oral argument, but the state has waived, and so, Mr. James, you'll have 15 minutes to present your argument. We've read the briefs, and we are ready when you are.
Very good. Thank you very much. Good morning, Your Honors. To please the court, my name is Jeff James. I, along with Walter Benson, are co-counsel for the appellant in this case, Gregory Kudla. Typically, I reserve time, but there's no reason to reserve time, so we'll get right into it. Your Honor, this case involves, and I'm sure that to some people, as they read the facts, they will find it somewhat egregious, but it involves an alleged sexual relationship between a father and his natural daughter. I'm not going to go through a recitation of facts if that's agreeable with you. If they're in my brief, I think both the state and the appellant have well briefed the facts that they were presented at trial. The issue that came into play, and I think the primary issue in this case that I'd like to focus on, unless the court steers me in a different direction, is the fact that in this particular case, the court gave a jury instruction on the use of force as an element of the crime of rape. In this case, Greg Kudla was charged with 8 counts of rape, 8 counts of sexual battery, which, following the jury conviction, were merged as allied offenses, 5 counts of gross sexual imposition, and 1 count of disseminating matter harmful to juvenile. This count, really, assignment of error 1 and assignment of error 2 are focused really on the 8 counts of rape. In this particular case, the court gave an instruction to the jury, which of course is predicated upon the Eskridge case, which is the 1988 case, that talked about when there is a special relationship, such as a parent or a person in an authority figure, that in that case there is a jury instruction to be given, and that jury instruction that is to be given is that force can be something different than what we would normally associate with force in a rape charge, but it could be something that would be psychological in nature, mental, so forth. That jury instruction was requested by the state in this case. It was given to the jury, and there was no objection to it at that time, so we are, of course, proceeding under a plain error evaluation here with regard to this assignment of error. I would point out that there's 2 things that's kind of understand, really kind of 2 points in this case with regard to that instruction. One is that Eskridge and its progeny, which of course was sham and die, ultimately led the Ohio Supreme Court to come and rule in a syllabus in State v. Dye in 1998 that when the victim is under 13 years of age, at that point a defendant may be convicted. Under 13 years of age, they may be convicted without evidence of threat or harm or evidence of substantial force.
But that's how that case was presented, was a child under the age of 13. That was the specification, right?
Correct.
So I understand your argument, but another argument could be made that they were just merely saying that when a child and a parent were involved, it's a special circumstance, and the force is different than it would be between 2 strangers. And it doesn't necessarily mean that they were just meaning in a situation of under 13.
Except for the fact that they have addressed that issue as we go back in Eskridge and of course then in sham. All right, in Eskridge we were dealing with a child victim, and they approved that instruction, jury instruction, kind of not negating but changing the elements of force. In sham it involved a father and a daughter, a natural daughter who was, I believe, 21 years of age at the time, and proceeded under rape, and they said, wait a second, no, this is not a person, this is a person who stands on a more even footing and ground, all right, with the defendant.
Because they weren't a minor.
Because they're not a minor. Well, it's just that that's the case that was presented. And then Dye came through with an authoritative figure, not a parent, but authoritative figure, all right, and that's when they came and they put it in the syllabus. And we all understand that the syllabus is what is the driving law of this state. I mean, we read, what the courts ruled many times, but when they put it in the syllabus, we take that to be pretty serious. because they have decided to put it in the syllabus, and in Dye, they put in the syllabus that when it's under 13, it's appropriate. That surely implies strongly that when it's over 13 and older, it does not apply.
Well, what do we do with our case law on this point? Would we have to overrule it?
You only have one case on that point, right? And the case
So we
that you
have to
have,
overrule that?
the case that you have on that is State versus Clay in 2005. It was an unreported case. To my knowledge, as I examined it, it never was appealed to the Ohio Supreme Court to say, wait a second, we think the 9th District has made a mistake here, and we'd like you to look at this. There was no appeal at that point. It appears to be an appointed case, and there was no money to pay for an appeal to the Ohio Supreme Court. Would I say that you were in error? Yes, because I have to. That ruling and the application of the Eskridge instruction in Clay by this court in 2005 was an error. But more importantly, we have another aspect of this case which I think is lost on so many people. And I understand this, and of course as I talk about this, many people question me about it. This was a very unusual situation. This was a situation where a young woman who was older than all the siblings, and because of the mental health issues that were facing the mother, who of course vacated the home because of serious mental health issues, was left to act in the position of mother to the rest of the siblings, of her siblings. And this relationship developed regardless of how we want to assess it. And I think that's what's important, is that when I look at the law is not supposed to have any bias or prejudice. We apply the law. We count on it being applied that way, right, regardless of the circumstances. And regardless, when we look at this relationship developed between this father and this daughter, all right, which led to the point that she assumed the role of mother. Everything indicates in this record that at no point was there anything but a consensual, voluntary relationship.
So essentially she assumed the role of wife and mother.
Well, I think she started assuming the role of mother, and it merged into the role of mother and wife.
Well, and there's also evidence in the record of substantial incidents of grooming. In fact, there was testimony, if I am recalling this correctly, from the briefs of a state's witness who testified regarding the incidents of grooming.
I don't know that it was so much about grooming as much as it was about the fact that there was this special relationship between the two of them. And she was somewhat shocked by that. So are you talking about the close friend of the family? All right.
No.
The ex-girlfriend?
No, there was there not a
Psychologist.
psychologist who
Oh.
testified?
Well, I mean, okay. So you're talking Cynthia McNulty.
Yes.
Yes, but when you look at the evidence as presented, what she predicated that upon seems to be absent. And I wasn't there to cross-examine Cynthia McNulty on what she predicated upon that opinion upon. All right, that was her opinion. And there wasn't much in the way of a counter-opinion presented at trial. But understand, that was just an opinion. But if we look at the evidence, we don't see a lot of evidence of grooming. What we, to the contrary, see is that when this incident was this history was revealed, we have saying, first thing to the police, it's not like Dad did anything wrong. Gregory didn't do anything wrong. This was always consensual.
Well, what was she, 8 years old, 10 years old when this started?
Well, the sexual relationship didn't start until she was 14.
Well, wait a second. I think,
There was evidence of touching.
yeah, I was going to say, what you consider to be a sexual relationship, the intercourse component, the digital penetration component for the actual rape charges. But to Judge Moore's point, he started having her sit on his lap, he started having her do different things and started talking to her about sex. The evidence was when she was in 4th grade, I think.
Well, I think it was earlier, all right? There was no question there was an issue of some touching that was before, but even it was somewhat sketchy, and there was not a lot of incidents, and there wasn't really a lot put in as far as how often it occurred. In fact, she herself said it did not occur very often.
But the psychologist took that in consideration for the grooming.
I'm sure she did. I'm sure she did. But the fact is that the actual sexual relationship, as far as an intercourse and sexual relationship, did not occur until the age of 14.
And I
according to the
understand,
allegation.
to make sure I understand, you're really only contesting the rape.
With regard to count 1 and count 2, I mean, on count one and count two, I understand they're somewhat symbiotic in their relationship. One is, of course, there's plain error in giving that instruction. Two was that it was ineffective assistance of counsel in failing to raise this issue, particularly in light of the evidence. So there's kind of twofold here. One is that not only do I believe that there's an error in giving the Eskridge instruction, all right, on the rape counts in this case, I also have to say that in light of the facts of this case, all right, and the testimony of everyone, all right, there was really no evidence of force to substantiate the 8 counts of rape.
Well, they did threaten to take her cell phone away.
Yes,
She's a teenager.
exactly. I would. And if we get to the point, and I understand, Judge Schaefer, I'm glad you brought that point up, because that point was critical in doing the analysis here. The things that she first repeatedly claimed this was a consensual relationship, nothing was wrong. Only at trial, when put under pressure of the prosecution to come up with something to substantiate 8 counts of rape, what were the ramifications if you did not do this? Well, I could be grounded. Well, what would that entail? Would take my cell phone away. Well, by the way, have you ever been grounded? No, in 10 years I've never been grounded.
Well, because she's consenting to a sexual relationship, she's never grounded. Isn't that consistent with her testimony? I would be grounded. Well, I consent to sex, so therefore I'm not grounded.
It could also lead to the other side, and that is that there's a relationship here which is really more like a father-mother, husband-wife. All right, I haven't grounded my wife in way over 10 years.
Well, you know, if you step back and look at the big picture of the oldest child whose mother, you know, had mental health issues and left the home, and she's left there with the father, you know, is it surprising that she would think that what's happened to her is normal if father says this is normal? And you can't be swayed by what other people think. I think that was testimony that he gave, that by what other people think outside of the family.
Actually, interesting, that was her statement.
Well, no, I know
Yeah.
she made that statement.
Right. Well, where would she get it?
Exactly.
I understand the implication you're making is where in the world would you get this concept that who are we to be judged by society's standards?
Right.
All right, and I'm sure that you're
And
trying.
so if she says, you know, he never forced me, well, no, he, you know, never forced her.
But we have a very specific statute that deals with these circumstances.
Yeah,
Called
I
sexual
understand
battery.
that, but we also have some precedent from the Supreme Court that.
Well, but Your Honor, then we're going to go to the point of, I mean, how far do you want to go with there's this psychological impact? All right. I mean, to be honest with you, when I was a 17-year-old boy and trying to date a 17-year-old girl, my first girlfriend, to some degree, did I use psychological impact? I'm sure I did. To some degree, did she use psychological impact? Of course she did. We were 17. I understand it, but how far do you want to go with trying to say, well, there was some psychological impact, or we're trying to imply that there was some psychological impact because of the nature of this relationship?
Well, what about...
Could go endless with that.
What about the fact that she witnessed him strike her sister because she was not compliant with him as to what he wanted her to do?
There's one testimony of that, and she was not, after being brought home by the police, and after being non-compliant, and then again going past curfew, and then coming home as he's out searching for her and finding out that she's come home. She's in the shower. She's in the shower because everyone seems to believe that she's in the shower because she wants to wash off the effects of the marijuana smell. That's really not on the record so clearly, but it's what was in there. That he got mad at her at that point, and he did smack her. That's the evidence of one-time smacking.
And he came into the bathroom while she was in the shower.
She was in the bathroom. She came to the bathroom, was in the shower, and he struck her.
And struck her on the face.
But
and
this
slapped her across the face.
But this, of course, wouldn't have had psychological impact of something that predated it. This whole relationship was really prior to that.
Well, but did anybody testify that that was just aberrant, unusual behavior from him? That he would, you know, do that to when he was a child? Didn't she testify that he yelled at her and was very angry and she was scared of his anger? No, I mean, I don't want to say the names, but
That's right.
The other daughter.
I don't testify too much that she was scared of her father. She testified that he would be grounded. was scared of the father, and that incident was what led to. There was no evidence of any physical force against any child prior to that, other than that incident, which that incident, of course, post-dated everything. That incident was just prior to the charges and the arrest.
And you have about 2 minutes. if you wish to.
Well, one second, Your Honor. Well, and I want to finish, Your Honor, in asking that the court look at the entire nature of the case. I mean, obviously, I've spent my time arguing on counts 1 and 2. We have raised arguments with regard to manifest weight, the ineffective assistance of counsel in this case, the failure to object to the testimony of Cynthia McNulty, which was really focused not just on that, but we allowed all of this testimony of Cynthia McNulty to come in with regard to her consultations with the sister, which of course I'm a little bit shocked that there was no objection to that in the course of trial as to what relevancy does your treatment of all right, at what point is it relevant to and not relevant to the case here as far as pending against Gregory Kudla and his relationship with. So I would ask the court to take a great deal of look at this. I mean, understand our position is very simple, is that these are very serious allegations that have been made, all right? And I'm sure they're shocking to many people, and they were shocking to the Kudla family, they're shocking to Gregory Kudla also. So I would ask the court to make sure that when I have focused on counts of 1 and 2, because I do believe that there is serious error with regard to the instruction on rape. Understand, I do stress this so much, and I have many times before, we can talk theory all we want to about jury instructions. But the fact is that we do believe, and everything that we do here is premised on the idea that the jury does follow the instructions, regardless of reality versus theory. And nothing is more sacrosanct than the jury instructions that we give to the jury. And in this case, it was simply error to give it with regard to the use of force. But I ask that the court look at the entire brief, look at it on its merits, and return a finding for Greg Kudla.
Thank you.
Thank you.
Thank you for your presentation. The court will take the matter under advisement. We will issue an opinion which will be sent to both parties, and also you may check the Supreme Court website.
Of course.
Thank you.
Thank you very
Have a
much.
good day.